Welcome to 4RG Meets, everyone. And for those of you that are new to 4RG, which I think there's one or two, this is where For Our Grandchildren comes together every couple of months to catch up and to listen to usually a guest speaker that will speak to a climate change related topic, anything from the science of it, the grief of it, the solutions, the actions that we need to take. And that's what we have today is a group of kids taking action with the help of our guest today. So my name is Scott McKinley, and this is
I'm
my
Beth
co-host
McKinley.
Beth McKinley. Yes, and again, we thank you for joining us on a beautiful May day where the warblers and other migrants are all into their motion from south to north, and the trilliums are blooming. The leaves on the trees are displaying all kinds of shades of green. If you look at a hillside, it's tremendous to see how many different colors of green there are. And so, yeah, you guys being here reminds us that people are still involved in climate solutions and climate justice. And so we really thank you for that. So, as I said, we've got a lawyer with us this evening, Reid Gomme, and with us this evening, and he's a lawyer with Ecojustice, and he's been focusing on public interest, environmental protection type cases, including representing the 7 youth who were challenging the Ontario government on carbon emission targets. But we'll talk a little bit more about that later.
However, I would like to offer the land acknowledgement and begin with For Our Grandchildren acknowledges that we are situated on the traditional lands of the Mississauga and Chippewa nations, and this area is covered by the Williams Treaty. So I'd like to take a moment to offer our gratitude to the First Peoples for their care of and their teachings about our earth and our relations. Now I'm going to go a little bit off topic here, but stay with me. There's one teaching in particular I've been thinking about this week. As the birds have been migrating in great numbers, and we're so lucky that we can see them at our back window. And I grew up in settler culture where people around me and the books I read used words like it to refer to animals. Never she, never he, definitely not they. But when I started to learn from Indigenous teaching that Indigenous people use familial terms, like father, son, and grandmother moon, all our relatives and kin. And I realized actually that these words made sense to my experience of nature. And that wasn't reflected in the culture I was growing up with. Now, this does connect to what we're doing tonight. And that is, we're still struggling with this misunderstanding, lack of understanding of these fundamental Indigenous teachings, that we are all connected, that we are all relatives, that we have a responsibility of care and stewardship. And so we find ourselves in this situation that Reid will talk about tonight, where youth are taking legal action to try to get the government decisions to reflect this understanding, the reality that we are all connected to one another, interconnected, interdependent. We have a responsibility to be good stewards. So I'd like to finish this land acknowledgement just by saying miigwech for these Indigenous teachings, and to the youth and to Reid and all the people that are supporting the Mathur case. And, bit by bit, the world is changing. Not as fast as we might like, but I'm grateful for the teachings. Before we move on to the presentation tonight, I'd like to turn things over to Robert Lockhart. He is the chair of our Community Action Committee, and he has an event and a call for volunteers.
Well, thanks very much, Beth, and excuse my voice. I'm at the back end of a cold here, and it's barking at me, and I'm barking at it, so I will try to be as clear as I can. So what I want to talk about is just briefly is on May the 23rd, we have our big home energy and EV expo at the McDonald Street Center in Peterborough from 10 o'clock in the morning until 3 in the afternoon. We're going to have all kinds of folks there who are in the business of providing things like solar panels and heat pumps, and they're in the energy business of one way or another, or the energy saving business. There'll be people there who can talk about how you can find grants and loans to get things done. And outside, we're going to have hopefully a good number of electric vehicles that people can come and look at and talk to the owners. And we have Plug and Drive coming in from Toronto. We're going to bring 3 electric vehicles that are insured to be able to be taken for test drive. One of them, in fact, is a pickup truck. The other two are 2 of the least expensive electric vehicles available in Ontario. So we thought we wanted to give that range to people so they can see how affordable electric vehicles can be and hopefully get rid of some of their fears and inhibitions if they actually get to go drive one. So that's what's going to be happening on May the 23rd. It's free, and I hope you're able to attend. And the last thing I want to mention is that to our membership, we're a little short on volunteers. It seems to be a very busy day, a lot of other conflicting things happening. And so we need a few more people to help us cover our booth and the lived experience table as well. So if you're able to, please connect with us and you put your name we'll put your name on a list and a time slot, and we'd be happy to have you there helping us out. So that's it, Beth. Thank you.
Thank you.
Reid Gomme is a graduate from the Common Law JD program at University of Ottawa in 2021. He has focused on environmental law, and that led him to Ecojustice through their clinic course at the university. And he then completed his articles and became a staff lawyer at Ecojustice in 2022. His legal work, as I mentioned earlier, has focused on the public interest environmental protection in the areas of administrative, constitutional, and Aboriginal law, including representing 7 youth plaintiffs challenging the Ontario government's inadequate 2030 greenhouse gas emissions reduction target for charter violations. He also represents a First Nations group challenging Quebec's free entry mineral exploration regime for failing the duty to consult and accommodate. But that's a whole nother story. Tonight, we'll focus on the youth action against the Ontario government. So welcome, Reid, and thanks for taking time to update us on this groundbreaking case.
Thanks very much, Scott, and I'm pleased to be with you all here tonight. It is very beautiful up where I am too. I'm up just east of Ottawa in the town of Bourget on unceded Anishinaabe Algonquin territory. And thanks for your acknowledgement and thoughts, Beth, on our friends flying around outside. I think it's ever more important now to think about them and connect with them and fight for them because we're seeing things like proposals right just on Friday from the federal government to consider changing things like the test under the Species at Risk Act to whether maybe sometimes it's okay to jeopardize the existence of a species when you're applying for permits to build things, for example. So these things are ever present on my mind for sure, and nice to hear from you as well on that. As Scott said, I am representing these 7 youth, and I'll share my screen when I go into the presentation. And what I think is just so interesting is like my journey on this as a law student and an arguing student and a lawyer. I'm actually like 1 year younger than one of the clients, and they're all youth as well. But in some way, this is, they do this full on their own time, just as advocates, and they ranged from 12 to 24 when they started this case, and now they're still going. And so I was so lucky in a way to be able to channel my concerns and advocacy into my day work. But these 7 have been doing it, as just side of their desk or evenings and weekends, and it's just so central to their lives, and it's amazing that they've kept this case going, and they're so committed to fighting for a better climate future on behalf of their fellow youth and future generations. So I'm very honored always to be able to speak on their behalf. I can never speak like they do to sort of their own passions, but I can speak to how those passions got converted into a courtroom and all the technicalities that come with that I'll go through tonight and try and keep it exciting because sometimes it's not. But the issues matter so much that I hope that'll all resonate with you folks. So I'd love to launch into my presentation now. I think folks can see my screen shared with the faces of the 7 youth. Perfect. So I titled this, and we've sort of had different titles when we do these presentations to different groups, but Generation Climate Action generally, since the start of the case, as you can see there on these t-shirts from the youth who got all together with that slogan in 2019, that's been central, that they are representing the public interest of a whole generation of Ontarians and Canadians really, who didn't want to wait any longer. Their voices were not being heard effectively for governments to take the actions necessary to protect their futures and protect the futures of future generations from the climate change we know is developing and coming. So these are 7 youth. You have from left to right, Shelby, Alex, Sophia, Bizi, Zoe, Maddie, and Shaylin, ranging at the time the case started here in 2019 from 12 years old to 24, who had all been extremely active in their own way in their communities, ranging from Thunder Bay down to near Sarnia and over to Ottawa, all across the province. Some had been taking action in their schools, like Sophia. She was the first to strike for climate on Fridays, modeled after Greta Thunberg and that whole movement to bring it to Canada. Others were working with either in their jobs or in their communities, volunteering so much of their time just to bring people together on climate action. But after the Ford government got elected in 2018 and really reduced the ambition of the province to tackle the climate crisis, um, they joined with some at Ecojustice who had been thinking about how do we defend against these types of decisions and bad trajectories for climate change coming out of Ontario in the courts. And so that's how the case emerged and brought us to almost 7 years later where we are today, and the case still goes on. So that tells you a little hint at what you can be getting into when you bring these things to the justice system that can move very slowly, but you hope delivers and has delivered along the way some helpful steps. So I'm just going to go through sort of the journey I'll take folks on today, going into a little bit of what brought Ecojustice to this case as well through our work. And of course, the thing that brought all of us to this is the issue of climate change. So not that everybody needs to go over all the basics or even the intricacies of that, but just a few of the points that really relate to why a case like this was so essential in Ontario. And then getting into the case itself, the basis for it, both in the arguments that were brought, why Ontario, why at the time in 2018, 2019 was it brought, and the charter basis for the case, which was quite a novel thing to move forward in a Canadian legal system. And then the case history. So once it got off the ground, it went through a lot of different stages, and it's sort of hard to encapsulate all the different hearings and procedures, but I'll take folks through that just to understand where it is now, and then where it might go next as it moves forward. And then at the end, we'll talk about how folks can get involved to support it or any of the similar work for youth and through Ecojustice as it suits you. And we'll take any of your questions because I'm sure folks have some. I still have questions about many aspects of climate change in the charter myself. So ecojustice and climate change, well, ecojustice in general, if folks know a bit, that's great. But if you haven't heard of Ecojustice too much, it's Canada's largest environmental law charity. And we have lawyers working here, law reform folks, communications experts, and of course, philanthropy folks who go out and make sure that as a charity, we reach people and connect and have the funding we need to do our work. And we represent community groups, nonprofits, Indigenous communities, and many individuals all across Canada who are on the front lines of the fight for climate and environmental justice. And so specifically on climate issues, some more recent examples that have been launched with pretty amazing folks like the youth, my colleagues suing Canada's largest pension investment manager over alleged climate risk management that comes from the way that they address or don't address climate change in the investments they're charged of. Examples of cases where, say, oil and gas being explored offshore in Newfoundland and challenging the processes and hopefully guarding against the worst outcomes from those types of deep sea oil projects. But then at times also joining with good policy and defending good governance. For example, when the government, at least at the time, had the boldness to defend a whole carbon pricing regime, and Ecojustice intervened on behalf to say in support of such a regime being part of good governance on climate in Canada. So these are just a few examples of where Ecojustice work takes us lawyers and that supporters can look for where we'll try to make a difference on climate. And climate change itself, of course, folks know the long history that really anyone in big decision circles has known for decades and decades now. But of course, decision making was so slow until finally ideas of really getting a global pact, a global plan together came about in 2016, really with the Paris Agreement and some good science that was putting together the International Panel uh, our intergovernmental panel on climate change, being able to put forward these authoritative reports so we can all start to understand collectively the impacts of climate change. And these understandings, the scientific understanding, is a huge bedrock of being able to bring a case like this because you have findings that are signed off by all countries all over the world who are part of that Paris process. And in 2018, together, those scientists were able to find important things like limiting global warming to 1.5 degrees compared to 2 degrees could reduce the number of people both exposed to climate-related risk and susceptible to poverty by up to several hundred million by 2050. So the differences in just half a degree are stark. And that's only to talk about sort of the range of warming that the Paris Agreement is trying to keep us at, let alone going beyond that as current trajectories have it going. Now, other findings are really important that were able to be found about climate change in these reports. For example, in 2018, at least, the finding was at that time, global emissions would need to drop by 45% below 2010 levels by 2030 to have a chance at keeping warming near that 1.5 degree level. Now, that was then. Science changes all the time, and the cumulative emissions change the impacts, but these snapshot really important findings of baselines for sort of a livable future resembling anything like what we have now are really important to take on the facts and try to get them into a courtroom. Now, youth and future generations, obviously, when they hear these things, as a young lawyer and my peers and the youth I work with, are very concerned when they read these things. And they think, well, how can we just know this? And yet we don't see anything happening with our government that plans for this or plans to take care of us and fight against this harm that they know is coming. So while you can go and hopefully convince people in policy, lobbying, ballot boxes, if that doesn't happen, of course, you have the chance to defend your rights and the facts of what you know is going to happen and affect them in a courtroom. So that's where these things linked up in bringing this case. But the question in Canada was, how can it be done? Uh, there were a few attempts in the mid 2010s in a court in Quebec. And then around the same time as our case was brought in the Rose case, that showed that it can be very hard to get the issue of climate change, which is a very, charged or portrayed as a charged political issue when really it's a factual issue about what's going to happen to our environment. But it's been hard to get it into a courtroom. But finally, over many, many tries, in some jurisdictions, there were groups that got through that difficult political question or anything that was blocking it to get questions of climate impacts into a courtroom on a human rights basis. And you can see here on the left, this is a photo from one of the first cases that broke through that door. This is in the Netherlands, a case brought by the group called Urgenda on behalf of a whole host of Dutch citizens who had a very similar complaint to what we ended up bringing in Ontario. And that was that their targets for 2020, I believe, at the time, were well below sort of the scientific consensus of what you need to match up with a future climate that respects the human rights instruments at issue in their jurisdiction. So that's the general basis of this type of case. And the question was, is the Charter of Canadian Rights and Freedoms the type of human rights document that can bring similar protection for those facing those same harms here, anywhere around the world, people are facing these harms, but it's the particular human rights document with constitutional rights relevant to us here in Ontario. So that was the task. How do you make that case out? And the first step is, who's going to make that case out? And as I said, the 7 youth here from across the province stepped forward willing to take the long road that can be years and years, even over half a decade now, in the courts to represent an argument that these charter rights exist for youth now and future generations on behalf of all Ontarians. So this is under a type of standing, as we say, to get into a courtroom where you're representing a broad public interest. So that was the basis of who was alleging that there was a problem with how the provincial government was addressing the climate crisis. And how was the climate crisis being treated by the Ford government? Well, at the time, one of the first things that the Ford government did when it came in 2018 under Doug Ford's first mandate was to get rid of fairly ambitious climate targets that were legislated by the previous government and replace them with one single target for 2030. The previous government had had targets looking much further into the future. And this single target, based on 2005 levels, set the ambition to reduce Ontario's emissions 30% below 2005 levels by 2030. And now you hear that, and it's good to have an ambition to reduce emissions at all. The issue is, we already understood in that same year that all around the world, emissions would have to be reduced at least 45% by that time on a similar baseline year if there were to be any chance to see that 1.5 degree world that the science shows if you go anywhere above that and start climbing and climbing, more and more is lost and rights are more and more affected for the people left living in those conditions. So the ambition of Ontario was quite a lot lower than the understanding of what sort of the world average needs to be. And there's no good reason why Ontario should be below the world average. And when you look at what Ontario is setting up as the trajectory, if everybody around the world was taking that approach, you're looking at warming far, far beyond 1.5, 2 degrees up into the 3 to 5 degree level, depending on the scenarios. So that's a very concerning trajectory to intentionally be orienting your policy on climate change around. And so what do you do about it? Well, these 7 youth consulting with Ecojustice brought up a case that said we want to ask the court for a declaration that Ontario's 2030 target of 30% below that 2005 level is unconstitutional based on the Section 7 rights to life, security of the person, and Section 15 rights to equality for youth, considering age can be a construed element of Section 15 equality rights. Also, the youth sought an order that Ontario, in setting a science-based target, or in setting a target, has to set one that is science-based, based on the sort of consensus factual understanding of where climate change is heading, and that it implement that target through its climate plan. And at the time, Ontario had a statute that said it has to have a target and it has to have a plan. And so it was easy for a court to see how, well, if one target is unconstitutional, Ontario has to replace it with a constitutional target instead. And so the combination of the statute and the charter rights was what sort of mixed together to make the case quite clear for these youth in Ecojustice to bring. And as I alluded to, the legal basis of the case was for Section 7 and 15. And as I already got ahead of myself, Ontario's target, according to the experts that we consulted and had bring evidence in the case, if everybody around the world was approaching climate change with that low level of ambition, you're looking at possibly 3 to 5 degrees of warming. And then not just the numbers, but what's the actual effect on Ontarians? Well, it will cause and contribute to an increase in the risks of a whole host of physical and mental harms and death as well, from whether it be heat waves, wildfires, flooding, and I'll get into in the presentation how we brought all that evidence into court, because it was really important to show the court we're not just alleging that there's life and security harms. These are pretty detailed depictions of what can be expected at different levels of warming. So that was very important to be able to make out. And then on Section 15, as I mentioned, youth and future generations with this type of future are disproportionately impacted. And there's different ways that they can be disproportionately impacted, is how the case is put forward. They will be more vulnerable, young people, say in 2050, anytime well into this future, as a young person, you're more vulnerable with a developing body and mind to many of the effects of climate change. So that's a different experience of climate change than a full-grown adult or of any other age. But also, these are youth who now or those born into the future will experience worsening and worsening impacts through further sort of percentages and durations of their lives. And then we also brought the point that Indigenous youth and future generations often living in ways very connected to the land and practicing rights, and for a lot of communities who are more in the north, where you'll feel even deeper or greater rates of warming and effects because of it. They'll have a disproportionate level of impacts because of their particular way of life. So these were all elements that were brought on the Section 15 equality basis. Now, you can put those arguments out in what we call a notice of application announcing that this is all being alleged, but you've got to prove it. You've got to lay down the factual record that can actually have a court make findings of fact to test against the legal charter questions. And it feels odd now, and I guess that's a helpful reflection on that these cases have been succeeding and moving past these hurdles. But this was a time when we didn't know how far we'd have to go on the facts of just proving that climate change was happening. It wasn't necessarily a given that you go to a courtroom and take it just as a fact without proof that climate change is happening, and of course the levels at which it's happening. So we had to do a lot of work, and luckily I came into the case sort of halfway through. So mostly my two colleagues who were on the case from its inception did a lot of work to get the right experts to set out that climate change definitively was happening, and in what ways and at what levels and with what effects. And we also had to show that Ontario's emissions were contributing to climate change. And obviously everybody's emissions are contributing to climate change, but there was a worry that we'd seen in similar types of cases or efforts to make this argument that, Ontario's a drop in the bucket. Nothing Ontario will do will really change this global problem. But we had to make the argument effectively that if everybody approached the problem that way, then this problem could never get solved, be impossible. And also that when you put together who is causing the emissions in the world, there's a whole, if you add up if you cut out the top 10 emitting countries and just take all the rest, they are still the vast majority, even though there's some really big emitting countries. So it can't be the solution that only the huge emitters are the only ones to take the action. Everybody has to take action to solve this global action problem. So we had to make that out and convince the court that we were right. And then you can't just make out that these things are generally happening, but how do they connect to the Section 7 and 15 harms? And for that, we relied on some sort of collective science, as I mentioned, the Intergovernmental Panel on Climate Change reports, the government's own reports, which conveniently over the years, governments come and go, but there's a lot of good scientists who do good science and good things get published. And so whether it be the Ontario government, the federal government, a lot of reports to explain what climate change is set to do here at home. And then we had 17 experts to give reports and accounts and a whole bunch of factual record on the effects of extreme heat here in Ontario, say at 1.5, 2 degrees and 3 degrees of warming, and the different death tolls that's likely to have in some of Ontario's biggest cities. And we're talking of differences of up to thousands more who are extremely likely to lose their life because of those different levels of warming. Wildfires and smoke effects, both generally, but also especially on developing youth and their lungs. Flooding and the impacts it can have with the variabilities that are going to increase as the climate changes. And irreversible tipping points, sort of these points where at 1.5 degrees, certain things start changing that really can't be reversed. And science from an expert going through when tipping points are best predicted to happen and what kinds of impacts they might have that are irreversible on Ontario. And then, as I said, particular impacts on youth, future generations, and Indigenous peoples, including permafrost melt and these sorts of things that will happen, particularly when you go further north in the province. So all of that amounted to, I think, about 20 to 30,000 pages of evidence. And now we look back and not all of it got, heavily looked at in every opinion, but you just don't know what you're going to need to rely on in these questions that courts for so long have been a bit afraid to grapple with. So we really wanted a very solid record with the most reputable experts so that the court could not be convinced otherwise that these effects are clear and set to happen and impact charter rights. And so all of that was set up, and we got to the Superior Court after a few steps that I'll go over at the end, sort of preliminary steps that still took a while just to get about 4 years later into the Superior Court for a merits hearing. And I'll get to what's on this page here first. It's sort of the downside of the case, I would say. But first, the good points of the case were that the court really adopted wholesale our factual record. So the clear understandings of the effects of climate change, that Ontario is contributing to it in a way that a court can measure, and that Ontario's contributions to it are having impacts on the descriptions of charter rights under Section 7 and 15. So those questions of justiciability, as we call it, this big word that just says, should a court even be hearing this question? The court said yes. And the causation question of, are the things that are before the court something that we can say these facts lead and connect to these constitutional rights and the harms that will be experienced? And the court said yes. The question was, is the charter a mechanism that can deal with those harms? And is there any obligation on the government to change its actions to avoid those harms? And that's where we didn't get the most favorable result from the Superior Court. As you can read here, Justice Vermette said, while it would be difficult not to be sympathetic to the concerns expressed by the applicants about their future in light of the evidence filed in the case, this court cannot, based on the current state of the law, find violations of the charter in this case. And so the application was dismissed. And really what Justice Vermette was talking about here was, in her view, Ontario's action in setting a target wasn't a type of action that has an effect to harm charter rights. She said, really what the applicants want is not to be free from the target itself, but just have a better target. And so that was her view of the case. She thought that the applicants here were seeking what we call a freestanding positive obligation to just say the government must act to tackle climate change. And currently, under the Constitution, that's really not how the Charter is seen to typically operate. Generally, it's seen as when the government acts, the effects of those actions against me, against anyone, are the things the court can step in to stop if they're seen as having an effect of harming our charter rights. And we had really put that this case, in many ways, is that type of scenario because the Ford government decided to set a trajectory of emissions that sort of guide and direct the emissions of the province in many ways that take Ontario towards that level of warming that is very harmful. And so the government is not just not involved in that trajectory and the impacts on Ontarians. The first judge saw it another way, and so that was sort of the center, the key center of the dispute that went up to the Court of Appeal. And when we took that case to the Court of Appeal, they saw things our way on this issue. So they said, in our view, the application judge erred in that analytical approach. This is not a positive rights case. The application does not seek to impose on Ontario any new positive obligations to combat climate change, but instead, they viewed it as specifically because Ontario enacted this Cap and Trade Cancellation Act that required a target and a plan on getting to it. It voluntarily assumed a positive statutory obligation to combat climate change and to produce this plan and target for that purpose. And so sort of a totally different view from the Court of Appeal that, yes, there is action being done by Ontario here, and it's all rooted in the statute. And that's not necessarily the whole of what we argued either. We had put forward a whole bunch of arguments to say, yes, through the statute, there's a clear target and that's causing these harms. But Ontario is involved in so many ways in causing harms, whether there's a legislated target or not. So that's not the whole story, we said, but there's different ways you can view it. And then we also had said in the appeal that if you do want to see it as a positive rights case, that this should be the type of case that merits positive rights under the Charter, because that door is still open. There was a case in the early 2000s, the Gosselin case, where the Supreme Court found that maybe in special circumstances, in the most extreme effects, there should be interpretations of the Charter that say the right to life doesn't require a prior government action to initiate that. The right to life is so sacrosanct and faced with so much danger that there is an obligation on governments to take positive action to protect it. We said, if not climate change, then what? So all of these things were before the Court of Appeal, but they really narrowly just looked at there was a statute. The statute said you had to have a target, and in following that, you have to set a target that complies with the Charter. And so even though the court only talked about that specific issue, it was a huge step to get that and really a victory for anybody trying to bring these types of cases because it meant anywhere that there is a target set by a government, that is seen as action that's going to impact us all if we're going to trust that we even reach it. Assuming we reach it, what's the effect? And that effect will impact everyone's experience of the climate. So that was a really important finding that for this case, they said we would like Justice Vermette at the court below to take another look at the case with that view. And we were set to go back and argue the case again this past December on the Court of Appeals view of the case. And it's also a determination that will, I think, help any case being brought that's similar to this. There's a case at the federal court that's going to go to trial this coming fall. West Coast Environmental Law and others representing youth. And they're going to the BC federal courtroom to say that the federal government's effects on their charter rights through the target and other actions are causing Section 7 harms. And they'll be able to use this case to say, as long as the government has a target set, as it really must under its international obligations, what is the charter effect of that on those 15 youth? So it's a really important finding. The problem is, it was really all premised in the Court of Appeals depiction on that statute. And, you would think that we're in a place in our political timeline where we all know what climate change is doing and what we have to do to stop it, that we, as a people, as a public, would insist on having a target. Unfortunately, the Ford government thought otherwise. So about 2 days before we got to the hearing in December, the government passed an expedited budget bill that included a provision taking out Section 3, which is the requirement to have a target, Section 4, which is the requirement to have a plan, and Section 5, which requires reporting on progress on those things. So instead of taking the real questions about the statute and the target that was set to court as was set up, the government decided it just wanted to try to repeal away those questions. So that's where we were. And as you can see here, it's been a long road where the target existed this whole time for about 6-7 years in place. And the effects it was having on the trajectory of Ontario's emissions were clear through that whole time through the court proceeding. And only at this point did the Ford government decide to repeal it. Yes. It depends which one you're looking at. If I'm not mistaken, it might have been the first clause in the budget in the fall economic statement that was brought out in November. But there's a few different versions of that fall economic statement, if that's what it's called, the fall budget.
As I recall, it was on like page 168 of 168.
That's where it was in the written budget. And then when they brought the bill, it was like right at the top. So, but people usually only read the written budget, and so down there it said other changes to acts and regulations or something like that.
It was totally invisible.
That's right. So in the written version, it was sort of an end note, right? The climate target was an end note. So that's the reality of maybe the moment we're in. I don't know what meant that the government felt it felt it was the time to do this, but unfortunately, it is legislation, and the legislature can at least take the action that it thinks it is able to take. So after that was done, we were pondering what to do and talking with our clients. And because it's such a drastic change to exactly the specific thing that the Court of Appeal first ruled on in good faith, and there were other questions left unresolved at the Court of Appeal, such as on positive rights and Ontario's overall actions, even beyond the statutory obligation on climate change and charter rights. We made a motion back to the Court of Appeal. It's still pending, so I won't get into it too much. But just asking them to reopen those aspects of the case that were not taken up, really in large part because this statute was there front and center and the one piece they ruled on. So we're waiting to see if the Court of Appeal can entertain that reopening. And if not, we might end up back before the Superior Court again in Justice for Met to hopefully resolve still the effects that the target, for example, had that can't be erased over the years that it's been in place and the trajectory that it has set Ontario's emissions on. So much is still unresolved, and unfortunately, the decision to get rid of the target, courts can't pass legislation themselves. So it's just indicative of some things have to be resolved, I think, through political pressure and civil society action. But some things can be advanced very well in the courts, including that if you're compelled by the public to make a target, the findings in this case so far are that it's going to have to be compliant with its effects on charter rights. And so that, I think, alone is at least a very important step that this case has taken. But hopefully it's not the only one it gets to take, and we still have some more good news to come. And so before I leave this slide, yeah, just a little bit of the history from November 2019 when the application was filed. I remember looking back at sort of what would be a great result in this case. Well, at the time, the hope was just that we could even get into court to make these charter arguments and put the evidence forward, because Ontario brought a motion to strike early on in the case. And what that meant was that Ontario was saying this is a political question. It's not the type of case that should even have full standing to think about the effects on future generations, because that's something a bit unprecedented. And for a whole host of reasons, they said a court shouldn't even consider this question. But luckily, for the first time on a charter climate issue, the court said, no, this is absolutely something we can consider, considering what we know so far, and we'd like to see more. We'd like to see the facts. And so we got to go into the facts of the case and set some precedents on courts grappling with climate change for the first time in Ontario. But I just like to look back down this timeline to remember that it was just a win even to just get into court to argue these things. And luckily we've been able to get a bit further on some of the other legal issues, not just getting the facts in. But hopefully, as I said, it's not the end of the line for where we've gone so far. So that's my overview, and it's already been a decent little while, so I want to leave enough time for questions. But I'm just going to leave this up here if folks are interested in getting involved in following this case, and the youth and who often share their stories in posts that we put out when there's updates on the case. Or any of the other work that Ecojustice is doing. If you want to stay informed, you can follow on all the social medias and mainly our website. I think it's been well updated in the past little while by the folks who work on that, and it's really helpful to be able to follow along. So I just wanted to leave that there. Okay, I'm happy to take any questions if folks would like to ask anything.
Before we jump into questions, and some people may need to leave as it gets closer to 8 o'clock or shortly after, but oh my goodness, Reid, I have so much respect for what lawyers do as you made it for the most part. I'm going to have to listen to this again, but just all the legal challenges, and you were able to take that and present it in a way that I got the main idea. And I just think about how much has happened. And like you said, there have been successes, but you've also said there's a journey ahead of us still. And yeah, we're just so grateful to have you here to explain it clearly. I was reading some of this stuff online in preparation for tonight, and I was just like, oh, it's just a lot. And so we're really grateful for that, and just understanding, what you have been able to accomplish in terms of actually having climate change dealt with in the courts and connecting it to the charter rights, and that we have a right for this, to this, not just the youth, all of us. And once again, we have kids who are 35 and 33, and it's just like, this is the time we have to do something. So gratitude to you for the work that you and your colleagues are doing, and the youth, and for giving us your time. Thank you.
Well, I'm always so happy to come in, especially to groups. Every time that we had rallies and things, the most amazing thing was to see the combination of youth groups and mainly seniors groups. And that's who was on on the hill in Toronto there. And so it's a pleasure to come in and share my reflections as best I can.
Thank you. Al or Linda?
Yeah. I mean, we have talked, 4 grandchildren has had a talk with a local member of parliament, and we raised these issues with him. His basic reply was, Canada produces such a small amount of greenhouse gases that I'm not even going to worry about it. And I mean, he doesn't seem to accept the fact that, I mean, I'm sure he's opposed to littering. I mean, he would object strongly if he saw somebody throwing stuff out the car window. And that's what we're doing. We're throwing our litter into the general space. But my question is really this. We know how serious this is. We know where we're headed. We're headed towards 3 to 5 degrees of warming. And I find it just incredible that our members of parliament either don't trust science, don't understand science, or don't believe it's going to happen. I'm almost incredulous about that. And I know you're discussing most of this with other lawyers. You're not talking with the individual MPPs in this case. Yes, it was MPP I meant, not MP earlier. But do you have any sense of where they're coming from, given this total ignoring of the crisis that's coming?
Yeah, I mean, I don't like to get too deep into political talk on, an issue that I'm helping litigate, but I think it is a bit indicative of the interests that are relevant in politics often are, relevant to the political actors and the horizons they have versus human rights are, I mean, forever. The principles, these principles of human rights come from decades and hundreds of years of human experience. And so if politicians don't want to reflect those in their decisions, then this is why these cases end up in front of the courts, whose job is between the common law that goes back through those hundreds of years, and constitutional law that, yeah, the charter's from 1982, but it wasn't the first time that all these human rights principles came out. They're much more embedded than that. So, I would hope that political actors understand that, and that our constitutional rights aren't going away, and the effects on them are going to be understood by courts who, at least if they can see these facts and have them well explained. I think in this case, when you read the judgments, even the lower judgment where we didn't get through all the charter findings, but the judge understood very well that Ontario has an impact. It's not a drop in the bucket. Everybody's emissions have an impact on the heating that we're seeing, and in fact, per capita, for example, Ontarians and Canadians are very responsible for these impacts that we're going to have and everybody's going to have. So I don't know if I have a perfect recommendation of what to say, other than I would say when it comes to human rights, it's not fully the choice of the political whims of the day. These things are everlasting, and so while it can be hard to set these precedents, and we might not be able to set all of them, it's a good stand to take when you do have political views that don't want to hear it. So I would say, at least from the courtroom perspective, that's what I can offer.
Thank you.
Marilyn, I think you have a question.
Yeah. As a lawyer doing the work that you do, you must have incredible patience. That these kinds of things just go on for years and years. I know that I couldn't do it. Just to Al's point for a second, any contact, well, all of the most recent contact that we've had, or rather I've had, with my MPP, who is a member of the Ford government, are now being answered by AI. And it's really obvious that it's being answered by AI. So now who even knows if anybody's reading it? I'm just really, really sad. However, my question is, how do you find the morale of the 7 youth over all this period of time?
I would say that their involvement and fighting against climate change isn't like because of this case. It's not contingent on this case. This is just one tool that they decided to use through all that they do. They're still very determined because they recognize that this is their whole future. Like it's never wasted in the sense of like when I talk to them. I mean, if you don't end up getting the result that you fight for, at least you showed people, whether it's in a court or on the streets or trying to get through to your representatives, you showed them a way that it can be done and the energy needed to do so. And so I think I've often wondered, like, will there be points of the case that are too hard to continue, and it would be fully understandable, but they've all stuck through it, I think, because whether this case is continuing on in court or not, the fight continues on, and this is just one place where hopefully some parts of it can be resolved. And so that's my read. It'd be much better to ask them. I'm sorry one of them's not here tonight, but I think even speaking just for myself, like it's sort of a similar view for me. Like this is just one tool that I'm privileged enough as a lawyer to be able to bring on their behalf. But it's not the only place. And so not seeing it as like the all and end all uh, is important. It's just one tool in the fight, and it's a tool that's important to try to use to the best we can.
Thank you for that. Rosemary, you have a question.
Thank you very much for agreeing to do this for us. It's been a legal seminar and a moral, ethical seminar too. My question is, does Ecojustice have an office, a staff, and a budget? And how is that budget built?
Yeah, so Ecojustice started as the Sierra Legal Defense Club or Defense Fund in and around Vancouver in the back of somebody's car in 1990. But now there are offices in Vancouver and Toronto, the main two offices, and then also in Calgary, Ottawa, where I am, and Halifax. And there's also lawyers working in other spots all across Canada. So it's decently large now. I think at times with the summer students who just came in to help, we're like over 100 staff total. And yeah, and that's fully reflective of the donations that we get from folks who want to see these issues brought to court, brought to policy, law reform efforts, and campaigns. So you can go on the Ecojustice website, you can go and look at like how much funding we've had to deal with to run all of this, all these cases and all this stuff every year. And it's directly reflective of donations that we get, mostly from folks who just donate a little bit here and there, or some folks who make quite large, amazing contributions because they believe in these fights. And that's the whole reason that we're able to do this as a charity.
Okay, thanks.
Guy.
I just have a personal question for you, Reid. If you're in touch with these young people, has Alex had her baby yet?
Yes, she did. You must
She
know
did?
her.
How is it?
I think she's doing well. Yeah,
Yeah,
we've had
good.
some nice updates, and
It was striking to me actually that these are youth, but she's already a mother.
well, this is the thing. Like when this case was launched, I mean, yeah, some of them were in middle school, Sophia and Zoe, and now they're both in university. Like Sophia's I see her sometimes here at university. So, um, the fact that they've gone through so many stages of their life and have seen not just their own lives evolve, day-to-day life, but also the realities of climate change and the effects that pick up along the case. Yeah, it's pretty amazing that they committed to this then and that they are continuing the fight on now.
Somebody had asked about how your morale is as you work through this over the years, and I was wondering if you could say something about the hope or inspiration or motivation that you get from other similar cases
Hmm.
that are brought forward by youth around the world?
I would say that's like maybe the greatest hope, at least from the legal perspective. It's realizing that, yeah, we're grappling here with questions of like, is this a negative right? Is this a positive right? These questions that not every jurisdiction has to deal with, where maybe there were constitutions and human rights documents that were written with a bit more of an understanding that, like, with questions like climate change, maybe it should be a bit more obvious that there's a baseline world that we need to have even have those rights be relevant and worth the paper that they're written on. So seeing the examples from those jurisdictions, like in the EU with the ECHR, the European Convention on Human Rights, which has, I would say, slightly stronger interpretations of similar rights. There was the Klima Senioren case of seniors in Switzerland who made amazing wins to force the Swiss government to start taking better action. I've talked to lawyers with a similar case in Korea that was able to advance in South Korea. Um, and so it's quite amazing to see those steps being taken by so many youth and feel that connection even with people that are continents away.
Mhm.
Um, and I think maybe folks noticed last summer maybe the most striking case yet, which was the ICJ advisory opinion. So not necessarily, automatically, and it's not like some sort of world jurisdiction where every court has to follow the result, but it's a highly influential thing to have the International Court of Justice say that when countries are taking action that is so harmful on climate, they may owe duties to other countries for those harms, and that there's sort of a general human rights expectation that countries not be taking such massive harmful fossil fuel action in the way they conduct themselves. So that ICJ decision was like a real helpful wind in our sails. And I think we felt pretty good until, you come back down with the federal government repealing the target law in November. So it's constant ups and downs, but there have been a lot of ups, and I'll say that whenever I open my news and I see another win somewhere, it's exciting to know that like it's not about one specific result. Honestly, it's about normalizing that these questions need to be asked in courtrooms, and the more that they are asked, probably the more we'll get some results that are really helpful for protecting rights. Uh, just by the statistics of how many things come forward in the world, win
Right.
or loss. Yeah.
Okay, thank you. Yeah, it is really interesting to hear, a line in an article I read says, it's been helpful around the world, but to hear you explain it that's really good to hear. Thank you.
And you've sort of touched on this before, but maybe I'm a little slow and I didn't quite understand it. So if the bill that you were working on, or the legislation that you were working on is gone, then how do you frame your battle going forward? And what is the case based on then?
Yeah, these are some of the questions still up in the air, because since the inception of the case, that legislation was there, and in part the case, when you describe the case for the court in the documents, obviously it's very relevant that there's a statute that says you have to have a target and you have to have a plan. So now with the repeal of having to have that going forward, I think that's the big question is, okay, if a government has taken certain actions to impact emissions, well, those can't be erased. So I think that's a fair thing to still look at is the impact before governments had on emissions and the resultant harms on charter rights. But what you do going forward is a big question because if that obligation to have a target is not in the statute from today onwards, then you might have to try to answer that question different ways. And that could be a finding that, well, there is some sort of positive obligation. The court won't accept that a government can just put up its hands and say, well, we don't have a statute on it, even while the government is still intimately involved in directing and influencing emissions that are happening in the province in a myriad of ways. Um, I think what the target gave and the expectation of a target from the populace was that it was a clear orienting policy and then legal piece. So you could present for a court very clearly well, at least one way that a government is very involved in the trajectory of emissions. Um, so, have to work a bit harder at explaining that to the court without that one document to point to, perhaps. But there are many other ways to answer the question and make out the arguments as well. So,
Right.
yeah, but it hasn't all gone through yet so far. But it's a really good question. Yeah.
You have to wonder the fact that they had a statute that provided some protection and then they removed it. Well, that's something harmful they did.
Yeah, and that's always been a question, for a court to say you can't, once you've taken an action in legislation, then the effects of that action are what charter harms are usually tested against. That's the traditional view. Um, Whereas repealing a statute, courts have generally deemed that's not something a court can really tell a government that it can't repeal, like, because the other side of that is you have to have the legislation, but the court doesn't want to legislate. That's not their role in the makeup of division of powers. So it's a fine line to have to walk. But even though a court might not be there to write the legislation, when we're talking about human rights baselines, if there is a right to life, and a government is just sitting back and not doing anything while that right erodes because of the climate harms that they are fully capable and very involved in bringing about. And we talk about emissions, no matter whether they have a specific legislative target or not. At some point, you'd think, well, the conversation has to has to have some solution in the courtroom, and so that's where that question, I think, is still not answered, but hopefully at some point courts are willing to answer it before we get too far along.
Right. And when do you expect to hear what the next step is?
It's a written procedure, so we're not totally sure. It could be any time, could be still some months, but there'll be a press release out if you're following Ecojustice when it comes out sometime, hopefully this summer.
Louise Brownlee has her hand up, but I'll just read a couple of comments in the chat. Rosemary Ganley says, I see that Louise Arbor's daughter, an Ottawa lawyer, is an NDP candidate, and Avi Lewis will make a positive difference. Yes. And then she says, Reid must have been a gold medalist at U of Ottawa.
I don't know. Nobody told me.
Oh, they didn't give you the
Thank you,
medal.
though.
Oh. But it's so good to hear how hard your team is working and the kids, sometimes when the negative fire hose of news, it's overwhelming. And just for me to remember, oh yeah, I know who you are now. And I know the names and the faces of the young people. And yeah, Louise, we'll pass it over to you if you'd like to unmute yourself.
Well, my local MPP is, he lives three doors down, and he has 4 daughters, and Stephen Crawford. But so of course I want to write him a letter. What did you think, Reid? And I am a supporter of Ecojustice. I think you guys walk on water, and I just, I'm with everybody else, fabulous work you're doing. But what did you think when they said, okay, let's just take away all our goals? Like, what was your first reaction to that?
I mean, you can't know exactly all the thinking and the timing behind the scenes, but it was really just a disappointment, a bit of a perceived affront to really having these important charter questions answered by a court as everybody had planned for, and to a couple days before the hearing as was planned to finally pass the law. I mean, it's a gut punch just for the process.
Yeah.
To get the honest answers that the public interest demands on these charter questions, and so I can't speak to the exact reasoning or what, but that's all that you can kind of perceive from it is that it's a bit of a cynical way, I'll put it that way, to avoid these questions proceeding in court as was planned. So yeah, didn't feel very good at all. We'll put it that way. And our clients were very disappointed because, the statute was passed and the requirement to have the target in legislation in 2018. And so, if if they thought that they didn't want it anymore anywhere along the case at any time, I guess they could have indicated to the people of Ontario that that's the direction they wanted to go to. But to do it at that time was a bit interesting.
They pulled the rug out from underneath you. And then this sort of is similar to the FOI, the Freedom of Information, you know. You
Yeah.
can't look, you know, you can't ask for any, I mean, they're doing the same thing, aren't they, as far as the Greenbelt investigation and, you know, it's just another one of their ploys, isn't it?
Yeah, and it's like, you go to court and you make a fair argument, or you have a freedom of information request, and there's already many valid ways under the freedom of information legislation to exempt things that are confidential under many parameters. So yeah, and people have to judge for themselves as the public of what they think of that, but definitely on the scales of the access the public has to defend their rights and to look for information that impacts their rights. It's disappointing because there should be, a somewhat more level playing field, so that the public can get those answers and fight for those issues without having it pulled out from under them. And so I agree. It's disappointing to see those changes happening when they're very helpful for the public to keep track of good governance.
So we've got to speak up, don't we? Anyway, all the best to you. Fight on.
Thank you.
So that looks like the end of the questions for now. So once again, Reid, so grateful for you coming out and making sense of this, because without going into a lot of research, it was like, so where are they now? Did they win? Wait, did they lose? Wait, what happened?
It's complicated.
It is complicated, and you've laid it out quite nicely for us to understand. So again, much appreciation for that, and we all wish you the best of the luck going forward.
Wonderful.
So,
Yes, thank you so much. Thanks
Well,
everyone else for coming out tonight and for your great questions.
Thanks for having me.
All the best.
All right,
All right.
take care. Good night, everyone.